Okay, so let's jump right into a fascinating case. Imagine this. Back in 2010, the cell phone company you chose could have actually changed your fundamental privacy rights. Seriously. Today, we're going to unpack the landmark Supreme Court case that hinged on this exact question, and you'll see just how much it affects our digital lives even now.
It sounds like a pretty wild question, doesn't it? But this wasn't just a hypothetical. It was the real-life situation at the very heart of the RV Telus case. And the way the court answered it would end up setting a huge precedent for how Canadian law looks at our private digital conversations.
So you're probably wondering, how on earth was this even possible? Well, it all came down to a simple, kind of nerdy technical difference in how text messages were handled back then. And this one little difference created a massive legal loophole.
And here's where it gets really interesting. See, while most providers just sent your text message on its way, Telus did something different. For their own technical reasons, they automatically made a copy of every single text message and stored it on their servers. This meant that every Telus customer, unlike their friends on other networks, had this stored record of their conversations just sitting there, creating a brand new target for police investigations.
And, well, that's exactly what happened. This seemingly tiny technical detail ended up setting the stage for a really high-stakes legal battle when police wanted to read someone's future text messages. The whole case boiled down to one question: what kind of permission did they really need?
So the police went out and got what's called a general warrant. This ordered Telus to hand over daily copies of all texts from two people for the next 2 weeks. But Telus, surprisingly, pushed back. They argued that what the police were asking for was basically a wiretap, and that requires a much, much stricter kind of authorization.
Let's quickly define these terms, because it's important. A general warrant, you can think of it like a legal multi-tool for the police. It was designed to give judges a way to approve new investigative methods that the law hadn't caught up with yet, to fill in the gaps.
A wiretap authorization, on the other hand, that's more like a specialized high-security bomb disposal kit. It's made for one specific, very sensitive thing: intercepting private conversations as they happen. And because listening in on someone's private calls is such a huge deal, the law puts up a ton of extra safeguards.
And this chart really gets to the heart of the whole fight. Getting a wiretap authorization is way harder. The police have to prove that other methods have failed, and there are all these strict reporting rules. The police were arguing, hey, we're just getting stored data, a general warrant is fine, but Telus was saying, no, what you're doing is the same as listening in on a conversation, so you have to meet that higher standard.
So this whole mess goes all the way up to the Supreme Court of Canada, and they were really split on it. We actually got 3 separate opinions from the judges, so let's start with the majority view, which was written by Justice Abella.
The majority's whole argument was built on this really powerful and I think common sense idea: substance over form. They basically said that technical quirks shouldn't be allowed to weaken our fundamental rights. The law has to protect what a communication is, not just the weird way it works. Their logic was simple. A text message is a conversation. Period. Your right to privacy in that conversation shouldn't just vanish because your phone company happens to store a copy for 30 days. They argued it would be manifestly unfair for a Telus customer to have fewer privacy rights than a Bell or Rogers customer, all because of some corporate policy they probably didn't even know existed.
Okay, so next up we have Justice Moldaver's opinion. Now, he agreed with the final decision to block the police, but he got there in a totally different way. He focused on what he called the no shortcuts rule.
His point was that the general warrant is supposed to be a tool of last resort. It's there to fill gaps. It's not supposed to be an easy backdoor to get around a more specific process, like a wiretap, just because that process is harder and has more protections built in. So Justice Moldaver didn't really care about the technical definition of intercept. He just looked at what the police were doing, getting all future texts every day, and said, you know what? That is substantively equivalent to a wiretap. If it looks like a wiretap and it smells like a wiretap, it should be treated like one. The police needed to use the right tool for the job, no cutting corners.
But not everybody on the court saw it that way. The dissenting judges, led by Justice Cromwell, argued that everyone else was missing the most important thing: the literal black and white words written in the law.
For the dissent, this wasn't about the spirit of the law. It was about the letter of the law. And they argued that the law makes a very clear fundamental distinction between 2 different actions, and you just can't ignore that.
So their reasoning went like this. The law draws a line between intercepting a message live, as it happens, and disclosing a message that's already been stored. They said Telus had already lawfully intercepted and stored the text for its own reasons. The police weren't intercepting anything. They were just asking Telus to disclose those stored copies. And since it was a request for disclosure, not a live intercept, the super strict wiretap rules just didn't apply. The general warrant was the right tool after all.
Whew. Okay, so you've got three totally different arguments on the table. One's about the nature of conversation, one's about preventing legal shortcuts, and one's about reading the law literally. So, how did it all shake out, and what does it mean for the rest of us?
The final vote came down 5-2. The majority opinion, combined with that concurring no shortcuts argument, formed the winning side. The general warrant was tossed out. And this was a massive moment for digital privacy in Canada. The court basically said, nope, police overstepped. If they want to get ongoing daily access to somebody's text messages, even if they're stored copies, they have to meet that really high bar of a wiretap authorization.
In the end, RV Telus was a huge win for a modern, flexible view of privacy. The court sent this really clear signal that our rights don't just shrink because technology finds new ways to store our data. The law has to evolve to protect the substance of our private lives, not just the old-fashioned forms they used to take.
So, the Telus case answered a really important question for its time, but it leaves us with an even bigger one for today. In a world of encrypted messaging, the cloud, and AI, how do we keep striking that balance between privacy, justice, and technology? That is the question this case forces us all to think about.